They will not allow. It's blocked at the entrance.
In the presence of, because you see when people make some statements, it gives them an option to permanently disappear. So are they saying there are other context here? Are there context
Tony. vidéo tafadhali.
Session number 335 of 2025, Uganda versus Kano, retired Dr. Kisa.
May it please the court, I'm Martha Karua, Senior Counsel, appearing for A1 and A2 alongside Arias Lukwago, Proskovia Kunihira, Aaron Chisa, Ms. Ansumbuga for A3 is not yet here. If the state may allow me to introduce them, we have Mr. Thomas Jatiko, Assistant DPP.
This is true.
Chief State Attorney.
That is true, my lord.
I think it affects the third as well because it's also made some.
He associated.
He associated with
matter was fixed for a ruling today, presence of all parties. There is no reason given as why counsel for history is not in court. But since history is in court, what will go ahead to deliver the ruling? This is a ruling on referees, constitutional court. This ruling is in respect of a request to court by counsel for A1 and A2 to refer the question of the law to the constitutional court for interpretation. The question, as proposed and framed by counsel for A1 and A2, briefly is that whether the court presided over by a judicial officer against whom is a complaint by the accused person in that court seeking removal, especially where the complaint is pending, is an independent and impartial court. In accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) of the Constitution, counsel for A1 and A2 moved the court under Article 137, 3b, which briefly states that where any question as to the interpretation of this Constitution arises in any proceedings in a court of law rather than a field of matter, the court shall, if any party in the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this Act. Counsel for A1 and A2 made submissions to the above. One said that all the submissions of counsel for A1 and A2 were put into consideration, but briefly they submitted that in light of Article 28(1) and Article 44(c) of the Constitution, there is a complaint pending against the trial judge before the Judicial Service Commission made by A1 and A2 seeking removal of the judge from the Constitution. Counsel submitted that there is a need to interpret Article 28(1) and 44(c) of the Constitution. That the question to be answered is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28(1) of the Constitution, bearing in mind that the article cannot be derogated from. That the question is whether, in its plain meaning, the court faced with such a circumstances can be or even seem to be independent and impartial, particularly for purposes of trying those people who have brought the complaint against them. Counsel contended that Article 137(5), paragraph 1, paragraph A, gives this court discretion, while paragraph B does not grant such discretion and is mandatory in its terms. Counsel further submitted that the article is framed in a way that court, while doing its work, may find an issue and make a reference that if any of the parties on whose behalf that work is being done asks it to refer, court must refer. What remains in the framing of the question. Counsel concluded that this court be pleased to refer the question of law proposed to the Constitutional Court for interpretation. Briefly, Chief State Attorney submitted that before court refers any matter for constitutional reference, it must be satisfied that there is a question of law, right for interpretation. That any matter which is disguised under interpretation that the actual sense of it is a violation of the human right is not a matter that this court can refer to interpretation. He submitted that the application is based on the alleged complaint to the Judicial Service Commission, but there is no copy of the complaint served to the judicial officer, which is the difference is intended to frustrate the process of hearing this matter. In rejoinder, counsel for A1 and A2 submitted that the role of the prosecutor in the court is to charge and present all the evidence and all times court justice. That the prosecutor is not a prosecutor and should always restrict himself to ensuring that the process is fair for all parties. Counsel further submitted in rejoinder that justice is about perception. It needs not only to be done, but to be seen to be done. That judges are human, and the perception of the man on the street is whether, in the instant case, this court will be seen to be fair to the accused persons. Counsel further stated that there is a question of law as to whether a judicial officer whom the accused persons have complained against before the Judicial Service Commission can continue to hear their case, and such a proceedings will be taken to be fair and in conformity with Article 28(1) and Article 44(c) of the Constitution. Counsel still in rejoinder referred to the cases, specifically the case of Professor Isaac Hamilton Job versus Uganda, preliminary number 33 of 1991, which relate to the question of perception as opposed to actual bias, and submitted that court does not look at the mind of the judge or when whoever it may be, but looks at the impression which would be given other people. Determination of court. It is now a settled law that references to the constitutional court fall under the ambits of Article 137 of the Constitution. Article 137, 5B of the Constitution, under which counsel for A1 and A2 moved this honorable court, provides as follows. Any question as to the interpretation of this Constitution shall be determined by the Court of Appeal sitting as a constitutional court. 5. Where any question as to the interpretation of this Constitution arises in any proceedings in the court of law other than a field court-martial, the court may, if it is of the opinion that the question involves a substantial question of law, and B, shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this article. Basing on the above article, the position of the law, therefore, is that a reference to the Constitutional Court is subject to determination by the trial judge as to whether there is a question for interpretation of the Constitution. In the matter of Sheikh Abdul Karim Sentamo and another, Constitutional Reference number 7 of 1998, the Constitutional Court stated that it seems to us that the trial judge sought that if any party to the proceedings requests a reference to the Constitutional Court, then the court was bound to agree to his request. In our view, the duty to refer the question if a party so requests is subject to a question as to the interpretation of the Constitution arising in the proceedings before court. This is clear from the provision of Article 137(5). It goes ahead to say that, however much a party may request, it cannot have referred a matter that does not involve interpretation of the Constitution, nor can the party give the court jurisdiction which the court does not have by law. See the case of Attorney General versus Milton Obote Foundation Limited and another, Civil Appeal number 7 of 1992. The Constitutional Court has determined that the applicant must go to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court. In the Constitutional Petition number 46 of 2011 and Constitutional Reference number 54 of 2011, in the case of Honorable Sambo Kesa versus Attorney General, at page 39, their lordships stated as follows: that both the Supreme Court of Uganda and this court, that is Constitutional Court, have in a way dealt with this issue. In a Constitutional Appeal number 2 of 1998, Ismail Selgo versus Kampala State Council and Attorney General, the rest of their lordships of the Supreme Court expressed no contrary view to the holding of Wamsi CJ, as he then was, who stated that, in my view, for the Constitutional Court to have jurisdiction, the petition must show, and on the face of it, that the interpretation of the provision of the Constitution is required. It is not enough to allege merely that a constitutional provision has been violated. Following the above holding, this court, in Constitutional Reference number 31 of 2010, Uganda versus Konza Francis, held that Article 137(5) should be read in the proper spirit of the Constitution, that the applicant must go further to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court. From the above decisions, it follows therefore that Article 137(5) A and B, the court deciding to make a reference must first be satisfied that a prima facie case exists or has been made out by requesting party, that an interpretation of the provision of the Constitution is required. If the court comes to the conclusion that this is not established prima facie, then no reference should be made to the Constitutional Court, whether under Article 137(5)A or B. It cannot therefore be said that Article 137(5)B takes away the independence of this court. In the instant case, briefly, counsel for the accused persons contend that since there is a complaint against the trial judge before Judicial Service Commission, it is against the spirit of Article 28(1) and 44(c) of the Constitution for the court to continue handling the case as the judge is likely to be biased and the accused persons will not have a fair hearing. Counsel contended that this arises as the issue that requires the Constitutional Court to interpret the above articles of the Constitution. Therefore, he is called upon to test the validity of the constitutional reference and establish whether there is a question of law that warrant constitutional reference under Article 137(5)B of the Constitution. I have very carefully examined the question of law raised by counsel for accused persons, to wit, whether a court presided over by a judicial officer against whom the complaint by the accused persons in that court seeking removal of that judicial officer from office under Article 144 of the Constitution is pending, especially where the complaint is pending is an independent and impartial court in accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) of the Constitution. From following authorities I have cited, I am bound with the same. It is this court's opinion, therefore, that the question of law proposed and framed by counsel for the accused persons for interpretation does not involve a substantial question of law for interpretation of the Constitution. The allegation that there is a likelihood that the accused persons who complained against the trial judge for the Judicial Service Commission will not get a fair trial is an imagination, because Article 28 of the Constitution lays down all the principles of the right to a fair hearing, which court is mandated to observe and cannot be compromised by the trial judge. I have put into consideration the cases referred to by counsel for A1 and A2, that is the case of Professor Isaac Newton of York. However, it is my finding that the authorities referred to relate to the bias, not directly relate to the constitutional reference. It is my view that this court is not satisfied with the question of law framed for constitutional interpretation. In the final result, it is this court's finding that counsel for the accused person have not made out a prima facie question of law to warrant reference to the constitutional court for interpretation. I accordingly decline to refer the proposed question of law to the constitutional court, and I direct that let the matter be fixed for scheduling and pre-taking the so-called.
Judicial sham. Yeah. We are tired. Yeah. It's a judicial sham. It's a no. This is a sham. Let me speak. It's a judicial sham. No, I will hit you. It's a judicial sham. It's a judicial sham. We are tired. We are tired. We are tired. Where is justice? Where is justice? Let me talk to him. Where is the justice? Where is the justice? Why are you doing this? Where is your parent? Leave me, leave me. Every time you wasted our time for one whole year. One whole year to journal so much script. Is this a theater? Is this a theater? Is this a theater? Get your script and take it to the theater. This is not a theater. I'll speak.
Who wished to come in and who were complaining that they were barred from coming in. They had been there since 8 o'clock.
That one we shall discuss, so we can have a meeting with security. Let us first get the post.
Justice. You people need to know what is the daughter was. It's the term of justice. It's not the balance.
So this being a public trial, we are urging the court to order the orderlies at the front gate of this court building to let members of the...
It's okay, we'll come back to that. Let me first go to the way forward of 315. I will come back to that.
Way forward, we were also going to come back to that. In view of your ruling, we will need to take instructions from our clients. We did not expect or know how the ruling would go. We naturally need to go and take instructions. We would also urge that the orderlies are impressed, the orderlies in court, even when removing a person who is agitated, they must not mishandle. They should handle people properly, and especially if it's a female, she should be handled with extra care, lest the handling amounts to indecency.
Have a matter that cannot wait. By and through now for the record. By and through now for the record. And of course, as I raise it, I would request that the record reflects the unfairness that is being subjected to our clients. Because my submission or my concern is premised on the same. My Lord, just as you might be aware, all of us on the legal team have roles. And one of my roles that are performed religiously for now a year is I am the one who visits the applicants or the accused persons. I therefore consequentially am the one who takes documents for execution, conducts prison interviews, etc. My Lord, the unfairness I'm trying to cite is that yesterday when I took documents for execution, the officer in charge of prisons, a gentleman I think called Besigye, ordered me to always be at the prison at 2 p.m. Now, my Lord, it's concerning because the law and the regulations of prisons say that visitors are received until 3 p.m. Now, our concern is, or my concern is whether the accused persons we have here in the law are a different breed of Ugandans, or they have a separate special of citizenship. As the point of time is noted, it is important, my Lord, that you also note that whenever we visit, we cannot even go with a static book to discuss with them the law. We cannot go with, I can't go with a paper where I have made notes to go and sit in a client interview. And my Lord, these are people who are charged with a capital offense that invites a penalty of death. But they meet counsel without adequate preparation, without, my Lord, my colleagues are even reminding me that even with a pen, my own pen, I can't get away with it. And my Lord, I have been in that prison, that specific prison, to represent other clients. And whenever I go, I am allowed to go with paper, pen, statute books, diaries. But whenever it comes to them, I cannot. And my Lord, it's concerning. It's actually one that should be on the record on if such amounts to legal representation that we can't even discuss with our clients what statute books say. My Lord, as I was studying, I was told by my professor that a good lawyer is the one who knows where to find the law. And therefore, I'm not in the business of cramming provisions to discuss them with my clients. I would need to go with the statutes and find the law to discuss with the clients. And therefore, we pray that court intervenes and makes such orders that preserve the rights of the accused persons, because it's disheartening, and that is why such incidents of outbursts are happening. Much obliged, my Lord.
The court has guided that this matter be fixed for scheduling.
My Lord, maybe before he comes in, I'm sorry, there's another prayer I wanted to make here.
Just been removed from the court. Just to bring to your attention, that she is the daughter of Mr. Obedi, and her emotions as a human being ought to be understood in that context. She obviously appeared to have something she wanted to communicate to the court. It may not have been communicated the way the court would expect. We are urging you to apply your discretion as a human being and to order for her release. She can be warned that next time she wants to communicate with the court, it's done differently. But just giving the court the context of the emotion that were outpouring. We will be able to sit down with her and listen with her. But also to again remind the court that all these frustrations are being exacerbated by the treatment of the public at the gate. So people are coming in charged after being totally mishandled at the gate. And that is not to excuse anything, just to provide the context.
My Lord, just the daughter to Etu was stated by the senior counsel here, is also practicing advocate. And one of the sureties whose particulars are already before this honorable court in a matter which was fixed for hearing for today. No formation for today. So in the event that my Lord court is pleased to entertain the bail application, Etu will not have his surety in court. reiterate our prayer for God's clemency on that issue under the circumstances. Regarding the issue raised by Council Bayan here now, there is also a related concern, my Lord, the privacy of the discussions between the lawyers and the accused persons. It's a right which is guaranteed under the law. Unfortunately, my Lord, oftentimes that right has been abused. Yes. On several occasions we have been there to have interactions with our clients. They are prison warders who are deployed close to the meeting place, and literally they participate in the discussions. They listen in, not even eavesdropping. They listen in, they are active participants. There is one interesting scenario, my Lord, when we are having a discussion on very sensitive issues relating to this matter with our clients. We had all converged there. At the end of the meeting, the prison warder made an observation that said that was a wonderful submission. The prison warder commending counsel for making a wonderful submission. Very, very disturbing, my Lord. That meant that actually they recorded verbatim and they are deployed for that particular purpose. My Lord, the rights of an accused person under Article 23 are well stipulated, well stated, including the right to be facilitated to prepare their case properly. And that sanctity of that right should be not only guaranteed but jealously protected.
As we address these concerns, the report for scheduling
My Lord, Senior Counsel had earlier indicated we need to get it on the way forward. We are entirely in your court, my Lord, to guide us.
My Lord, in light of our
request that we are allowed time to speak to the accused persons. Before they are returned to confront the debate.
that one is okay. As the latest tentative
where we're asking, just perhaps before we go there, the last time we were allowed to speak to them, we went down the cells. I don't blame the prison because they're not in charge of those cells. The circumstances are very challenging, even
that one is okay. That latest idea, we can confront here tomorrow.
my Lord, we request for, in light of our schedule, please request for 3 weeks. What we can return to get in 3 weeks time, but can arrange our affairs. Come to court for that process. not the other one because it might get straight under the carpet. It's a request. Last time the court allowed us to interact with our clients. It was in that situation. Even when they had their counsel next to them, they were still handcuffed. We had to arrange a makeshift bench arrangement in the corridor itself. And of course, as one senior colleague said, no matter which is smaller than earshot of prison officers. And my lords were given 5 minutes and a final extension of 2 minutes. We can request, my lord, I believe that the prison officers can reserve for this court that we have time to speak to our clients in the courtroom. As that we are also officers of court, and we will tell our clients what's expected of them because they are under remand, therefore under prison control. But just so that we can speak to them. Mindful of the fact, my lord, that Mr. Trinawa said all of us can make sure by the time we go to the clearing system in the prisons, we can't have a sufficient time. The last one, my lord, is that we regret the incident. My lord, I was one of those people that also raised my voice to be able to come and hear that as well. My lord, in the more rigid environment we are in as much in the court martial, my lord, the soldiers around the public, the council of Canada, is a military establishment. We expect a lot better from the civil environment. My lord, even then the trial officer, chairman, in retrospect, following the events which happened to our colleague, Mr. Peter, noted that perhaps his charges had gone overboard, getting the pressures and emotions to rise. So we beseech you, my lord, to intervene in the correct way. We would advise our member of the public whose emotions run high about the hospital. We appeal to inner minds, so these are right. Direct that the officers will address our question, both for counsel and also subject.
May I add in one point on the cells down there, they were actually on that day in unsanitary. And it's not just for us as councils, it's also for our clients because normally I've attended many facilities here in Uganda, including the jails and they're quite clean. But down here, something was wrong. There was no water, and it was like we were inside the small room where other things happened. So, since we do not know where else we can address this issue, so that also their dignity is also maintained and that of other people who are held in the cells, just to request that it's the duty of the court also to draw the attention and whoever is in charge of the cleanliness of the building, that the conditions there should be such as give a human being dignity. It appears that every Mr. Ola is raising his hand.
My Lord, instances. And since I've not worked in this commission, I have a kind of request. It has not taken me 2 years to prison, but by the grace of God, for the very first time today I've seen him president. I would like to request you all to kindly allow me to have time to interact with my mother and my family's before we are together. And we have to establish from them as a wife, lawyer, did not come and away.
She's a work at the points on the quality of the officers and the grades. One point is that they broke the lawyer from entering the release camp. The name of the lawyer is called Simo Plateau. And limiting the number of people attending these proceedings, the officers that they get. And the relationship is important to emphasize to them that if they have amended the Constitution to remove the fact that this is the public cause, that the public should be allowed to attend, or if they have a specific number of people who should attend this court, we need to know that, otherwise that the misconduct by the armed forces at the gate is both unconstitutional and a flagrant abuse of power. And we pray that this court brings this to the grinding hour. So,
Performance assistant people. Why don't we associate ourselves with the prayerful and journey for purposes of scheduling of this hearing of the main case. And my Lord, we humbly pray that this court be pleased to grant us 4 weeks from today and takes us to the 4th of December, my Lord. And my Lord, the reason is that starting next week we are having panel cases before 4 judges. My Lord, one of them is the case of Jamil Mukulu, the other one is Joan Kagezi, and the third one is the one case again for Katumba Wamala, my Lord. And it is in these 3 weeks, my Lord. We humbly pray that this court be pleased to grant us the 4th week, that is 4th December, my Lord. We humbly pray. As opposed to the 3 weeks that defense has requested.
This question is raised by the situation at the gate.
We undertake also to find out about these allegations about the denial or delay of persons coming into court. And especially since it is a matter handled by the security, it would need for the prosecution and the defense to come and have a dialogue with the security. Because we cannot confirm nor deny, because we do not know that.
With your permission, I would just like my colleague to know that we feel disrespected by him calling our eyewitness account an allegation. At least give us some credibility as your colleagues. We were able to say I and Bukwaro passed without any incident. But we are giving an account as officers of this court. It's not an allegation. You require us to swear by the Bible we are available.
unfortunate situations described at the gate, even at prison. Can I propose to have an engagement with the team and the prosecution with me?
We have no intention.
That's a week now.
Some accommodations here we can take.
So, schedule. That's what I'm saying we shall schedule and take 3 and enforce December. Scheduling and pre-taking at 11. And for engagement, and for engagement by the consent of both parties, I am available even today, after seeing the client. You can come to my chamber that engagement. You can have another date before that.
Another day I'm able to valid market components that is the factor in the single code.
If it's another day.
So you discuss then as for engagement.
I think I'll let my colleagues handle that because even today I have a flight. Which is that.
Team, we get another date. Otherwise, the matter is actually to enforce December.
And if you fix it with the register, the engagement.
My lord, you didn't mention about the young lady. He pleaded with me. Then we will come to the chambers in that case.
The pronouncement about interacting with our clients in the court. Because they are going down the stairs and to be at us with the questions.
Page 2 of 2025, Valerie Dr. Besigye and Hajji Obedi.
My lord, the appearances
in agreement with prayer.
This matter is a journey information.
We are also blessed that we urge that some of us will follow you to chambers on that matter, while others will remain to see our parents.
I have another
Okay, didn't it?
Yet another disturbing ruling from the Court of Justice Babuma. You are aware several times you have appeared before him. We have failed several applications, unfortunately. We have never succeeded even on a single application. Not one has been granted in our favor. It's so strange. All the applications we have filed before him, including bail, recusal, now constitutional reference, they have all been thrown out without considering merits of the same. This last one, we failed to find the sense in the submissions that we made, because really it touched on the core of the criminal justice system. That is fair hearing. That is the cornerstone of our criminal justice system. That the accused persons who are applicant Dr. Besigye and Obedi have no confidence in his report. They have not trusted that he will dispense justice. And that is the thrust of Article 28 of the Constitution. And the Constitution, our constitutional framework created that latitude, whereby if you are dissatisfied with a judge and you feel like there will be no dispensation of justice, you raise the matter. And if you are not satisfied, you seek for a constitutional reference. Unfortunately, again, he has dismissed the application without any justifiable reason. So, we are definitely going to challenge it. We have discussed with Dr. Besigye and Obedi, and we have instructions to challenge the decision made by Justice Babuma today. And we are going to take the necessary steps to pursue that matter elsewhere. I may not be at liberty to disclose the particulars of what we are going to do. all I have to tell you that decision is going to be challenged at another level. So these are the instructions. Mirundi mingi tuzeewa Justice Baguma ekisinza okwewuunyisa tetuwangulangayo ka application nakamu tutaddeyo akusaba kwaffe ku nsonga nyingi bail applications ndakumize muziraba neya mandatory nagoba recuse tuzze emirundi mingi nga tugamba kuva mu musango guno ng'amateeka bwe gagamba n'alemeramu then katwatuuse ku point egamba nti kakati oba owulira nga ensonga zifaananye bwe zito kati tugende mu kooti entaputa ssemateeka kubanga n'eryo eddembe ly'abakyuzi okusaba nti bwe balaba nga embeera teraga nti wajja kubeerawo obwenkanya mu kukozesa omusango gwo baddembe okugamba omulamuzi nti ffe tutidde ennyinga 28 bawo obuyinza obwo ya ssemateeka nti tutidde olabika tojja kuwa bwenkanya infact si bakyuzi persons bokka nebamemba ba public basaba kirabo nti embeera ye kooti eraga nti wajja kubeerawo bwenkanya ate nga kooti etaputa ssemateeka yateekawo omuwaatu ogwo nti singa omuntu aba tamatidde waddembe okusaba nti ensonga eno kale tugyongereyo mu kooti etaputa ssemateeka yebeera mulaba ekyo nakyo twakimusa nekyakigaana atlantis bafuusima amateeka n'ensonga eno benyamivumu decisions justice Baguma zazakola era nga ssemateeka bwalambika bwobanga tumatidde n'omulamuzi asooke wansi olina eddembe eryeyongerayo batuwadde instructions gamba nti Justice Baguma gyasazeewo olwaleero ngeyongereyo walala tubuukamu era tujja kubabuulira emitendera gye tugenda okukwata okuwakanya decision ya Justice Baguma.